Should we start?
Sure.
Cool. Good evening, everyone. Thank you for joining us for today's session with Khaitan Legal Associates. We have Ms. Shruti with us and Mr. Dheeraj. Welcome, both of you,
Thank you.
for the second session that we have today. This will be a workshop on contracts and force majeure during COVID-19, a very, very pertinent topic in this crisis. So over to you, over to both of you for taking the workshop, and for our audience, please be very attentive, and whatever queries that you might have, keep dropping them in our comment section and we will take them up by the end of the session. Over to you guys.
Thank you, Kritika. As always, a pleasure being here with all of you and trying to do a little bit of supporting a very vast but a very, very critical community that is perhaps one impacted, but also perhaps the only nimble-footed soldiers that we will have that will see us through beyond this current scenario that we are dealing with. So, hello everyone. Good evening. Just as we are beginning to kind of move on, despite the continuing COVID-19 impact and the aftermath of the COVID-19 impact, we are thankfully seeing some spurt in the economic activity and some favorable support that the government is looking at, augmenting for the industry for it to kind of begin to get back to some work despite the lockdown and despite the virus not finding any easy answers yet. I thought it's time for us to look at contracts and related concepts of force majeure and frustration and contingent contracts, whatever that entire gamut is. And of course, Dheeraj knows better in how to solve for them. But in that whole concept, how should we look at it as a going forward tool? While concepts are necessary for us to understand, and we will look at addressing and answering those questions or giving a brief flavor of what the concepts are, and given we have perhaps found a way of dealing with the impact that the lockdown had on us, but what's equally critical is that given if they are such key tools to a contract, how are we using them in the going forward scenario of solving for it and of beginning back some kind of economic activity? It's indeed the beginning of a new cycle and newer times, while responsibly closing out the pre-March 29th era. So as Kritika briefly mentioned, I have with me my friend and colleague Dheeraj. And while I'm the person who drafts out all the contracts and puts all those fancy words and language around force majeure, etc., there, he's really our champion who we go to whenever we fall into tough times and the contracts are not going as per plan. So he's a bailout expert, and he helps us decode both what the provisions may entail and how can we solve for it. And what the beauty of the support that Dheeraj perhaps provides, which is why he is the expert, is how do we solve for it while keeping the commercial relationship to the best possible way going and intact? So how do we solve for it without perhaps looking at the fait accompli of ending those relationships? So as usual, I'm not sure if some of you were there in our last session or last workshop that we did on employment law. I'm going to be on your side, and I'm going to be asking him all the difficult questions as he's going to go along the presentation and help us understand definitely the concepts, some inputs on how can we still complete closure on the impact of the lockdown. And obviously, most importantly, how are we beginning economic activity going forward and looking at contracts as a tool to create new relationships in the new areas. So over to you, Dheeraj. And please know that for this session, I'm on their side.
Thank you very much, Shruti, for the introduction. Today, we have decided to actually take you through certain important provisions of the contract and legal provisions and discuss them briefly because we are conscious of the fact that there must be a absolute webinar fatigue on these concepts and and we are already many people have already dealt with this issue and many must have dealt with the fact that how you can deal with any issue that you've faced right now in view of force majeure on the existing contracts. So whilst we will be dealing with the existing issues also, but the focus will also be on how you can actually deal with this in future. Because now we are going towards lifting of the lockdown, so we need to see how we can deal with these situations in future as well. So
And Dheeraj, if I may just add, it's very, very pertinent because contracts will become a key tool, especially in this, in these critical times where there are winding up of operations or organizations facing closure, where there are declining revenues in the more than the majority of ecosystem, and with everybody having very limited cash runways, especially in the startup ecosystem. I mean, majority will perhaps be having very, very perhaps minimalistic cash runways for the future, and contracts will perhaps become a key tool of navigating through these difficult times. So I just wanted to add that for your.
No, I agree with you, and it's very important that in today's day and age, there's nothing which actually is as important as contracts. Every obligation, every relationship is actually dealt with a contract, and therefore may it be a restructuring, may it be a merger acquisition, may it be a simple sales or any business development. Everything is covered under the umbrella of contract. So therefore, it is very important to go back to the basics and see how we are actually looking at our contracts and not ignoring certain relevant and important clauses which we otherwise would have ignored.
Yes.
So force majeure being one of them. Dispute resolution is another. Dispute resolution is definitely the second one. But as you rightly pointed out, that we are seeing a decline in their disputes per se, and which we will see more in this year because it is prudent to not fight but to resolve the issues, negotiate the
Absolutely.
contracts, and make it easier for you to perform your obligations rather than fighting in court. Because apart from the tedious process, the amount of money that one can lose in the whole litigation process is something
Yeah.
which one should look at, especially from the cash crunch perspective. So
Absolutely.
uh, I'll just start with a basic presentation that we have made. Quickly run past through the concepts and certain important issues that we have highlighted for startups, and then we can have a good brief discussion as to what are the issues that we are seeing or other foreseeing in respect to the startups and how we can deal with them right now, or at least prepare ourselves to deal with them. So I will
Got it.
start with the presentation first. So as we said that the basic for the presentation is that we need to deal with what is the impact of COVID-19 situation on the contractual obligation, what is the impact of COVID on the performance, and how you can deal with the aspect of non-performance or if there is a default in performance. Uh, we have prepared it on the basis that because of COVID-19 and the lockdown, the contracts could not be performed, payments could not be made, and many parties have went ahead and they have actually triggered the force majeure event in their contracts. Many parties were fortunate to have a good force majeure clause to actually interpret it in different situations. And we have also seen contracts where there was absolutely no force majeure clause, and which is very shocking. But as I said, that these are some clauses which are often actually ignored, but now considered to be very important. So we will focus on force majeure. We will
Yeah, going
deal.
forward, we will perhaps see very little contracts with no
Yeah,
force majeure, especially if it's a
exactly.
contractual right.
Right,
And
exactly.
and what will become very relevant from, like you rightly said and very very validly said, it's not just about having a clause there. It's having it address your purpose.
Right,
Because if it's not just about some fancy language there. It's about it must be tailored to your purpose and it should be solving for your problem
exactly.
going forward.
Exactly, and which is very critical because assuming that parties go in finally get into a dispute, the courts have actually looked at force majeure clause very strictly, and the lens that the courts apply is so strict that it is often difficult to actually twist the language of force majeure clause and say that it is applicable in all situations. So from the drafting perspective, it is very important that we draft a good force majeure clause which will actually cover exhaustively cover all the situations that we may foresee in respect of our contract. In addition to the force majeure aspect, we will be dealing very briefly with the material adverse change clauses and the frustration of a contract. And we will see the nuances or the differences, like very slight differences between these concepts, and try to understand when and what, when, in which situation, which particular concept can be used or rather can be utilized whilst even drafting our contract. Moving forward, so we will first deal with the concept of force majeure. As by now everyone would be knowing that force majeure means superior force. It's a French term actually. Now, what it actually means force majeure is an event which is beyond the control of contracting parties and which actually affects the performance of the contract. So, an event which is like a war or a natural disaster or an act of God, as we at times say, and this act of God is actually interpreted on several occasions. It can be a pandemic, it can be an epidemic, depending on an event which is considered to be a force majeure and added in the contract as a force majeure event. The force majeure can be ascertained from your contract. It is very important to know that force majeure as such is not a term which is provided under any law or any statute. It's a term which has been incorporated in the contracts. And if you do not have a force majeure clause in a contract, you do not have the ability to actually invoke that clause or take benefit of that clause. Now, the intent behind adding a force majeure clause is to actually exonerate a party from from failure to perform their obligation under the contract, or to protect a party from from any liability that can arise due to failure to perform the contract. So, to put it simply, two contracting parties may agree that upon happening of, let's say, flood, if parties are unable to perform, then in that case there will be no liability for delay in performance, assuming that post the flood situation recovers and parties are able to perform. Or parties can also agree that, let's say, for example, in the case of a war, if the war breaks and if there is a situation that people are not able to perform their obligation under the contract, parties can agree that such non-performance, they will not be actually punished or rather penalized for such non-performance. Uh, there are very good force majeure clauses that we have seen which very meticulously cover not only the event but what happens in upon happening of an event. How do you notify a party about that event? And upon subsistence of that event for a certain period, the contract can be terminated. We always encourage parties to actually put such detailed force majeure clauses, because then you not only understand what is a force majeure event, you also understand that what can be the impact, or what a party can do upon happening of an event. This often parties miss. They add force majeure as an event, but then they do not add, what will happen if a force majeure event occurs, which is very funny at times, because we have seen that parties terminate the contract on the basis of force majeure, and actually the contract doesn't even talk about anything of that sort. So
So
we
there's
need
a
to.
bunch of learnings here, Dheeraj, that you're giving us. Those are actual pearls of wisdom. One, it has to be an event. Two, it is has to find mention in your contract. Three, it has to be very, very carefully worded so that it's fit for purpose, like they say it in commercial terms.
Right.
And four, most importantly, it must be covering the event, it must be covering the consequences of the event, and it must also say how are you going to go about notifying each other and taking the conversation forward in terms
Yes.
of impact and resolution both. I think
Yes.
these are very, very valid, inputs, and perhaps very simple yet critical to achieve as we do new contracts.
Yes, Shruti, actually, we are in fact advising a client, an American client actually, has a contract in respect of technology and developing a software for banks. And they have a very beautiful force majeure clause which actually deals with all these situations, including lockdown, and we are trying to actually enforce that. So it deals with not only, it gives exhaustively not only the events, but how do you notify the party, and if the event subsists for more than 60 days, what can be the effect and how the parties can come out of it. It is a very beautifully drafted clause, and it is always advisable to have such a elaborate force majeure clause to get benefit of it, at least as and when it is required. uh, so, coming to the clause per se, as I said, that it is basically a part of the contract and it is not a statutory term. So, if it is not in the contract, parties cannot take benefit of that. Secondly, it is important that upon happening of an event, regardless of it affecting your ability to perform or not, it is important that if you are going to take shelter of force majeure clause, you must notify the party that we have entered into a contract and I am performing my part of the contract, but this force majeure event as agreed under the contract has occurred. I am saying regardless because you can always analyze whether it is actually affecting your ability to perform. It can make it difficult for you to perform, it can make it onerous for you to perform, but that does not make it impossible for you to perform. So therefore, by notifying the party, you are at least notifying the party that if there is no there is if I'm not able to perform my part of the contract, then in that case I should be exempted from any liability or any damages for failure to perform the part of the contract. At the same time, assuming that I have notified the party and I can see that probably it is becoming difficult for me and onerous for me, but I can perform the part of the contract. At least I have the ability to say that whilst the event did not make it impossible, it made it onerous for me to perform. So therefore, I want to sit with you and negotiate my part of the contract to say that okay, I'm able to perform at a higher rate, so you please change let's negotiate and change the value of the contract. Or I may be able to perform in a month, whilst under the contract I had to perform in 10 days. So I can agree with the party to say that okay, let's modify this term of the contract because this event has affected my ability to perform, not completely but in a certain way. Therefore, it is necessary for the contracting parties to sit and negotiate. Like the termination of the contract, as many parties say, upon happening of the event, ought to be or should be considered as a last resort, and that too even when under
Absolutely.
under the force majeure contract, you can clearly establish that event has occurred and event has made it impossible for you to perform. There is no way you can perform your part of the contract, and that event has subsisted for a period of more than 30 days. Therefore, your contract provides you that now you can terminate the contract. If you are able to follow this process, then only I think it is advisable to terminate the contract. Otherwise, it is always advisable, and we always tell our clients that instead of going into the technicalities of force majeure, if you think that certain event has made it onerous or difficult for you to perform, it is best you actually sit and negotiate with the party to change or modify the terms of the contract, because the courts look at it very strictly. I have referred to a case of energy watchdog where courts have, time and again said that just because performance is onerous or the performance is difficult, it does not mean that the force majeure event has occurred, or you can take benefit of force majeure event. So it is very important. I mean, we have seen in last 2 months that people have actually tried to invoke force majeure in every possible situation, and I'm pretty certain that or if all of them go to court, probably 10% or 20% of them will be able to sustain or actually explain that yes, they are able to take certain action under the force majeure clause. So the point is that it is very important that we draft a clause in such a manner that if it comes a situation that we have to enforce it in court, we are able to show all these things, all these ingredients, so that the court will come to a conclusion that the force majeure event has occurred. If we are not able to establish any of the ingredients, then there is enough precedence to show that the courts have not considered a particular event as a force majeure event and has actually not granted any exemption from damages. So therefore, I want to point out to you is that force majeure clause, when you are analyzing in your contract, it is very important that you analyze not only the clause but also the fact that there are certain ingredients of force majeure that need to be proved before the court. And if you are certain that those ingredients are available to you, then only you take a decision of invoking force majeure or taking shelter of force majeure.
So you say a very valid point here, Dheeraj. Despite being the person who will be very happy if there were a dispute, you are actually saying let's word it properly. Let's make dispute or litigation our last resort. Let's
Yes.
word it in a manner that it helps us to commercially negotiate a viable position so that we do not have to look at an eventuality of termination. That, and obviously that is key to it being worded properly, because while you may prepare for the end result of a dispute, but it will help you also negotiate very well commercially, and this can actually become a very key tool for organizations going forward to use it judiciously in their critical contracts, where we now need to envisage for situations that could impact workability.
Right.
So
We've
thank you. That is very useful.
we've often seen these kind of clauses in infrastructure contracts, Shruti, because those are very important contracts, and obviously there is a certain tender process which is followed by the government, and it makes no sense to just ask the parties or allow the parties to terminate the contracts on upon happening of such events. So in all infrastructure contracts, we have seen that parties generally add that upon happening of a certain event, the parties expressly add that they will have an ability to negotiate the terms of the contract, including the timelines to perform the contract, which is a very good initiative to do it. So I think
Yes.
from that perspective, force majeure clauses need to be looked into very clearly and added very consciously.
Thank you.
Okay.
That's helpful, Dheeraj. That.
Um, I think that is there for force majeure. I'll go to the next slide, and we will take this slide very quickly. Actually, this is about material adverse change. Now, we must have heard about this term, and I just wanted to make a distinction between force majeure and material adverse change. Material adverse change is basically a clause where contracting parties agree that whilst they are actually in the process of finalizing the transaction, or just before closing the transaction, actually they add a certain clause that says that if before closing certain event happens where the event is actually not that relevant, but the effect of that event is relevant. Now, two contracting parties can agree that because
Which kind of contracts would you usually see this in, Dheeraj? So from the startup's perspective, what kind of
yeah.
contracts may perhaps have this?
So from startup perspective, I think many financing contracts do have this kind of clauses, because all the banks, or if suppose a angel investor is coming
Any
or
investment,
investing, yeah, then in
any
that
investment.
case we have seen, in fact, it so happened that before this lockdown, we did actually advise one investor on some material adverse change clause, where they had agreed to invest, and before the closing and this lockdown happened, and they decided to not actually go ahead with the investment. So, and they said that we will take shelter of material adverse change clause, but
So this
uh,
may find a mention going forward for the purposes of the audience here, that investors or banks or any other financial institutions who they may be reaching out to, this may come in as a mention from the perspective of conditions for giving money.
or I would just say I'd go one step ahead and say that you please look out for this clause,
Yes.
because because this clause is very critical, and it any impact of any event on your financial position, or the position in respect of your asset, uh, can actually decide the fate of the investment. So let's say investor may add a material adverse change clause, which may read like this: that upon happening of an event, as I said, that event is not important, but they can just simply say, upon happening of an event, if the financial position of the company goes down by 10% or 15% on the revenue side, or on the balance sheet side, or a certain asset which value of which depreciates to a certain extent, let's say by 10, 20% or 30%, then in that event the investor can decide to not go ahead with the investment. So material adverse change clause is a clause which actually contemplates an effect, or other a situation where the investor or the contracting party can actually terminate the contract upon happening of an event which has a material adverse effect on the company or the target company. So the slight distinction from force majeure is that the force majeure makes it it's an event which is beyond the control of the parties and makes it impossible for the parties to perform. Here, more than the performance, the emphasis is on the impact of the event on the target company, and if the impact is covered under the material adverse change clause, then the ability is there to terminate. Again, the courts are very strict about interpreting this. No party, I mean, we have rarely seen any case law actually where, apart from one or two actually, where courts have accepted that yes, material adverse change clause has been triggered because happening of a certain event led to the reduction of the financial position of the company, or adversely affected the asset position of a company, and therefore there was an ability for the investor to move out of the transaction. So this is a different breed of a clause, but it is very important to see if your agreements do have material adverse change, because an investor just before closing the transaction can move out of the transaction. So this is material adverse change. I think we'll go ahead, and then if there is any question on material adverse change, we can take, right, Shruti?
Yes, and as Kritika said, we'll be taking all the questions at the end of the session. So, I'm sure people may have some interest in this one, given it could be a watch out clause going forward.
It is definitely.
And I'm sorry,
Um,
I apologize. I went off track line for a moment, that digital and power cuts go hand in hand. So, I had to come back.
um, Next topic is frustration. Now, you know, this is a term which finds place in the Contract Act actually. Now, if there is no force majeure clause, and if there is no material adverse change clause, and upon happening of a certain event, performance has become absolutely impossible, then in that case the parties can resort to frustration and notify the contracting party that because happening of a certain event, it can be an event as covered under force majeure, or rather any event like a flood or natural calamity or anything which affects the performance of the party. It need not be those events also, it can be any event. For example, I'm actually manufacturing and selling certain masks, and suddenly in India, because the production is so less, there is no masks available in the market. So I may have a contract with a party to procure masks and sell masks at a certain rate. And if there is no mask available in the country itself, or in the neighboring countries, then I may say that, because there is no availability in the market, I cannot perform my part of the contract, which otherwise I would have performed if there was availability of masks in the market. So frustration is basically upon happening of an event. If you are absolutely unable to perform, and the performance has not merely become onerous or difficult, you have the ability to say that there was a contract where I had agreed to do a certain thing, and because of happening of a certain event, I am unable to perform. That this has led to frustration of the contract. So
This is
this
perhaps the only thing available to us under law to date.
right,
And going
right.
forward, I think I can see lesser and lesser people relying on chance or this legal protection to kind of save the day for them going forward under contracts.
Yes, I completely agree with you, Shruti, and very good point that you made, because frustration is the last resort. It means that I will terminate the contract, and because I am unable to perform, you cannot argue frustration and then say I want to modify the terms of the contract. Because when you say frustration, it necessarily means that the contract stood frustrated, and there is an absolute impossibility for you to perform. So therefore, it is advisable to the parties that if they resort to frustration, which means they are resorting to termination of the contract, which always will be a last resort if performance has become absolutely impossible. I am just repeating that just because performance is onerous or difficult, that does not mean frustration, because there is an ability to perform the part of the contract. So therefore, frustration as a legal term can be utilized by the parties when there is no force majeure, no material adverse change, and there is an absolute impossibility to perform. So therefore, parties can terminate the contract and move on.
And this may have been a perhaps the last resort of organizations thus far, where when they've woken up and found themselves not having any pertinent clauses in their contracts, or the clauses not serving the purpose for which they were there, for
Right.
both force majeure and MAC, given the tests and the rules of application are so stringent and the bar is set so high by our judicial systems. I
Correct.
think it is recommended, and I'm taking the liberty of recommending it to the audience going forward, that please, given contracts are made for a future and a future of commercial purpose and satisfaction for both parties in the contract, frustration, please do watch out for putting force majeure or material adverse change clauses. Make sure that they work for you to the best possible scenarios going forward, and uh, frustration becomes the last resort for any one of us to be looking at going forward.
Very interesting fact I want to share with the participants actually. Uh, though all these terms sound similar, but often we have seen that force majeure or material adverse change is actually invoked and rather argued by the parties who are invoking force majeure, and frustration is taken as a defense. So often you will see that if a party is suing another party for non-performance, you will see frustration as a defense rather than seeing that some party is going to court and saying that because of frustration, I'm unable to perform. So which is very, very funny actually, that thing which we have seen often in courts, that force majeure and MAC is often used by the plaintiff and frustration is often used by the defendant.
Interesting.
So, in all these circumstances, whether force majeure, whether material adverse change, or frustration, what is the fallout or what is the consequence that we can see? We try to actually sum it up, that what are the possible outcomes that we are seeing in these cases? Is that one, you can have a lawful termination of the contract and seek exemption from performance. Two, as I said, you can negotiate the terms of the contract. So you can have a deferred performance or suspension of the performance of the contract, or alternate mode or manner of performance. So you novate or rather change the terms of the contract and you agree on alternate mode or a deferred performance, maybe deferred payment also. We have at times seems that parties interpret the force majeure clause wrongly and they wrongfully terminate the contract. So in the event that you would want to take shelter of force majeure, it is necessary to see that whether you fall under the force majeure clause or not, because termination then would lead to damages and specific performance of the contract. So if you have terminated a contract and the court comes to a conclusion that the termination is wrongful, then party can either get specific performance of the contract, that you can be asked to perform your part of the contract, or the party can also get damages for non-performance. So
This is very critical, Dheeraj. Sorry, I'll interrupt here
yeah.
from the perspective of all the participants here, because while a large majority of them may not be the ones invoking force majeure, there may be a large majority definitely out there against whom force majeure is being invoked, and that and and going forward also, they may, while they may have agreed in well defined scenarios or clauses, but that in case that be the position always, even going forward, then how, what should be the ramifications perhaps as we go along? That will be a very important question for you to help us answer.
Yes. So as I said that you have to, for first thing first is that you need to analyze your force majeure clause. Even if from the termination perspective, suppose your contracting party has terminated the contract, taking shelter of force majeure, the first thing which any lawyer will do is to see the force majeure clause and will try and find out whether all ingredients have been met or not. And if you are able to show or establish that all ingredients are not met, or at least most of the ingredients are not met, then in that case you can always go to court and say that this person has wrongfully terminated the contract, and therefore you would want either specific performance or you would want damages for wrongful termination. So it works both ways. If you wish to terminate a certain contract on the ground of force majeure, you must analyze this, or rather, if not, you can always take advice of a lawyer. And if you want to actually analyze if a certain termination in your contract done by other contracting party is wrongful or not, then in that case also you must analyze the clause and see whether you have the ability to sue the party in court or maybe in arbitration, whatever is available to you as dispute resolution, and seek damages for such wrongful termination. Does that answer your question, Shruti?
Yes, it does. Thank you. Thank you.
Now, what we have done is that we have generally seen that now COVID has happened. We're already in on 60th or 61st day of lockdown. So, what is the effect of COVID on the contracts from the startups perspective? How it is affecting the startups from the performance of the contract perspective, their operations, to manage the cash flow, or generally, there is a demand drop in the demand per se. So these are the effects that we are seeing, which are there because of COVID situation. And I think we need to. I think this is the most important slide, I would say, because the questions would come in this slide per se as to how do you deal with that, the the situation in respect of what has happened in last 60 days, and obviously the situation going forward, because we have to now look forward and see how we are able to sustain this situation and also deal with the other impacts of COVID-19. Like, for example, though we are looking at lifting of the lockdown, but we are also seeing that people will not go out of their homes so soon, so easily. Many companies have already said that they will still work at 33% or 50% capacity. So there will be a drop in demand on several things. So how do we deal with these things, and how do we actually see whether certain difference or modifications in your existing contract can help you or not? So Shruti, as we were discussing some time back, these were the issues which I think were important, and we can actually, have a good discussion on these aspects as to how we can deal with these issues.
Yeah, and in fact, each one of them is relevant from a going forward perspective, Dheeraj. Like I said, that we are perhaps coming to terms with some resolved and some not so favorably resolved ways of our existing contractual ecosystem. But I mean, like I was speaking with you briefly before our session today. Clearly, as I see it, contract becomes the magic key and the magic tool for any going forward relationships, be it closure, be it reworking them in the new concept, in the new dimensions, or creating new partnerships or newer or green shoots that may emerge with this scenario. So, in all of this, while contract, as we say, are futuristic and are for solving a particular purpose, but it's also about looking at how are we dealing with eventualities that don't go as per plan. So,
Right.
in that context, it'll be very helpful, Dheeraj, if you were to kind of uh, help us understand the contracts of the future or contracts of now, and how should we be looking at them, creating them, and helping them navigate way forward for us.
So this is very interesting because you said contracts of the future, because now whatever contracts we have executed, we can't really do much about it, from only from the perspective that if there is some wriggle room, I would advise that for the existing contracts, please try and negotiate them, please modify them, and novate the terms of the contract in a way that you are able to perform, or the performance is not affected in any manner, because ultimately if none of the contracts are performed, it's going to affect your cash flow, it's going to affect the entire system per se, or the operations of the company. So from the future perspective, because this is very important, and we have been talking to various market players, and as to how they will now look at the contract, or rather how they will draft the contracts in order to cover such eventualities, and in order to have some flexibility so that parties can always perform their contract and not end up in dispute. Very
Or a
interesting.
leg room, or some leg room to negotiate if the
Yeah,
situations go tough,
yeah,
perhaps.
exactly. Very interestingly, when I started practicing, my senior said that in India all contracts eventually go into dispute. So we,
We're
we
changing the law now.
we have to change the law, we have to change the scenario per se. Certain points which I would keep in mind when I'm drafting or rather negotiating a contract is that parties generally, when they are negotiating a contract, they are only looking into the commercial aspect of the contract or the performance aspect of the contract, which is obviously the most important thing, because ultimately we are into business. But at the same time, it is important to look at force majeure, look at dispute resolutions, look at insert clauses which will actually give you wriggle room in the event you see, or you can foresee that there is a certain event, or which will affect your ability to perform. So I think there is going to be some more discussions or deliberations that will happen when each and every contract will be drafted. Maybe a service contract, like for example, if you are giving an IT service to a company, and due to such situations, you are not able to in fact deploy resources at the place where you are giving services, that becomes problem. But at the same time, you have to maintain servers, you have to maintain all the services, you cannot stop them. So therefore, you need to come up with a system where you can negotiate with your party as to how you can actually remotely also deal with all the problems, or remotely solve the problems, even if you're not allowed to go to their office per se. It may obviously incur more cost, it may obviously incur more technology, but at the same time, considering the whole social distancing norms that we are going to follow now, it is more important to see how you can work remotely. So therefore, all the service providers need to see how they are able to work remotely, and maybe put in systems that can really help to resolve the issues. I'll share a very funny incident that because of this lockdown we are not able to go out, and suddenly the Wi-Fi service provider decided to shut the shop, and he did not come, and suddenly one day we have no Wi-Fi, and we were thinking that there's absolute breakdown, and this the person's service provider is saying that sorry, I cannot open the shop. But I said, okay, fine, but do you have the ability to remotely deal with it? He said, no, I don't have it, but my main service provider has it. So it is very important to have this kind of solutions available, or agree to these kind of solutions in the contract, in terms of your pricing, in terms of your
I
hardware, so that you can deal with this.
I do see a pitfall there, and I'm sure a lot of participants perhaps have a question also. And given I think like them more than like lawyers, um, the pitfall that I'm worried about is, will everybody get so overtly cautious that this may just become a roadblock into workable contracts with a little, I mean, obviously contracts will need to have an element of risk there. So essentially, the pitfall to watch out for that I'm getting worried about now is that, it shouldn't make us all very cautious, and we will have to find workabilities and take the risk. The leap of faith will still remain, perhaps.
I agree with you there, and I think the appetite to take risk will, I think, for some time be limited to the foreseeability of the risk. And
Yes.
if something is unforeseen, then obviously you can't deal with it. But I think parties will start looking at all these risk factors to mitigate them in a way, so that the contract is getting performed seamlessly. So I think the whole discussion or negotiation has to be from the perspective that you foresee all the risks and you try to mitigate them in the contract per se, so that tomorrow you don't have to terminate the contract, or you don't have to modify the terms of the contract. Obviously
But
it
look
is
at them realistically and workability perspective. I mean, you
right.
will not have all the right answers and all the right solutions.
I agree with
And
you.
caution is good, but over caution perhaps may be counterproductive.
Is not good. Yes, yes, I agree with you there. Similarly, in if you are looking for investments from various investors, you
Yes,
please
that was my second question actually.
yeah, because that is another thing, because I've seen that during this period the cash flow situation has been affected really bad, and ultimately affects the valuation of the company per se. So therefore I think whenever you are looking into investment contracts, you should have some wriggle room. You should have the structure in place in such a manner that if you see that there is going to be a problem in repayment, then you please find investors who are ready to invest in equity, or you make a combination of debt and equity in such a manner that it doesn't become onerous for you to repay the loan. So if it has a simple debt structure, it can be slightly difficult for you. But if it has a debt and equity structure, probably you have the ability or the wriggle room to offer more equity in case you see that you are unable to deal with the debt situation. So that could be one of the solutions. Another solution is that you have to have some wriggle room to say that upon happening of certain events, if it affects your performance or the operations, then you should get some relaxation or deferment in making payments, like how RBI introduced it, and it was very welcome move actually for many businesses, where RBI said that okay, in terms of term loans or either any other loan, we will give a 3 months moratorium. So you need to
Yeah.
have a clause in the investment agreement also, which is not unheard of actually. Many investment contracts do have a clause that which will actually identify that upon happening of a certain event, you can get a moratorium from payment.
Yeah.
Another thing that can be done is that insure your investment, because insurance is something which will help you actually deal with this when you are unable to pay. So for example, if you have taken certain loan and certain term loan, and you have insured it, in such scenarios where it affects your ability to pay or repay, then in that case at least insurance will cover you for some time. So these are the
Dheeraj, if
things.
I may interject, there are, by popular demand, there are a bunch of questions waiting for us out there. And
Okay.
I'm sure with the RBI and the 10% of our GDP, fueling us back into action, perhaps more on the supply side than the demand, as is being the popular voice out there. I'm sure we have some interesting questions waiting for us. Kritika and Gautam, requesting you to perhaps show them to us so that we can answer all these aspects that Dheeraj has helpfully put here inside of those questions.
So this is my last slide actually. I'll just stop here and
Yes.
we can stop sharing so that we can.
Yes. So the first question is from Chandrasekhar Sakala. Dheeraj, I'll read out the questions so that you can perhaps look at them. Can you
Thank
please clarify if the events leading to force majeure or MAC could be pointed policies, local, state, or federal constituents like court, NGT, etc., or central government agents? Is there something missing in this question? Could be pointed policies. Could you please clarify? There
So
was something
changing.
missing in the question, I guess. Or perhaps, Dheeraj, you can attempt.
So change in government policy can be considered as a force majeure event. We have often seen that, for example, if I'm holding a land and I am entering into a development contract, development agreement, and for some reason the user of the land is changed due to certain change in the government policy per se. To have forest area, to have this much area for development, and the user of the land itself is changed, then that is a force majeure event, and I can always take benefit of that even and say that now the though I had agreed to enter into development contract, but now I can't give you because now my land is converted into forest and because of change in policy. So therefore that can be considered as a force majeure event.
Got
If I'm
that. Okay. I thought you got the question. I mean, I was still struggling with it. Okay, so the next question is from Sohail Ansari, and he wants to know if performance is possible, but would put the party performing at a huge loss. Can the party invoke frustration? I think we answered this, but again, you should
Yeah,
perhaps
I will.
say it
Uh,
out.
I'll just repeat that, just because performance of a contract is onerous, which means at a huge loss, that does not make it impossible for you to perform. So the ability for you to is to go to the party and say that yes, I can perform, or rather, if I can only perform only if you are able to modify the terms of the contract. If the party doesn't agree to modify the terms of the contract, then you have reached an impasse, and then you can say that because you are not agreeing to modify the terms of the contract to make it possible for me to perform for you, then in that case I cannot go ahead and perform my part of the contract. So parties do negotiate this and agree, but you need to have good physical data to back up your claim that it is a loss making it is loss making for me to perform my part of the contract at the current commercial rates. So therefore you need to change the commercial terms of the contract, and that's why it is important to have some wriggle room to modify the terms of the contract.
So the
You
next
do,
question is from
yeah.
Lenina. Should frustration be put as a clause in the agreement of or contract? That's a very good question.
Yes, it's not required because the protection is under law, so you don't need to put any clause for frustration. Anytime when you are able to say that you are unable to perform your contract, you can seek the benefit of frustration by informing the by notifying the contracting party that the contract stands frustrated today. You don't have to add that clause in the agreement, but you must add a force majeure because that is not covered under law.
Srikant, we're looking for solutions if a force majeure clause is not included, and what are practical ways around it? Negotiate, negotiate, negotiate. Over to you, Dheeraj.
So, as I said, that force majeure, we always look at force majeure clause very differently. I think in every contract, it is not only force majeure events, but there can be events which can actually impair your ability to perform the contract. So, therefore, rather than restricting yourself to only limited force majeure events, you should look at actually adding a certain term in the contract which will help the parties to identify a certain situation as a situation where have the ability to sit and modify the contract just to ensure the performance is happening. So force majeure is definitely there important, but suppose there are events which are not covered in force majeure but have the same effect on the performance, then what? So you need to have a certain clause which will help you next sit and negotiate the contract before performing it any further.
Shrikant, it's all about workability. Your relationship, existing relationship with the contracting party, and your both parties intent to conserve and retain and preserve the commercial relationship. And with these three intents being there, I think a practical way is always possible. And it is about looking at conversations and communication that makes it workable for both parties to look at it. That perhaps will be the best practical solution around. Can you please let us know who's authorized to declare an event that comes under force majeure
If the parties who are we had a
contracting?
case where one party claimed force majeure. Right. So, as I said initially, you need to agree. The parties must agree and put exhaustively that these events would be actually force majeure events. So, for example, if you have act of God, you have flood, you have and you don't have earthquake, then and if you want to say that earthquake is going to be a force majeure event, whilst you have the ability to argue that earthquake has affected your ability to perform, but you cannot say earthquake is a force majeure event. So therefore, that's why you have frustration that when force majeure doesn't come to your rescue, at least you can say that my ability to perform the contract is completely affected, and it is impossible for me to perform, and therefore this event is not covered in my force majeure event. I am seeking frustration. So
Trick
part
question here, Dheeraj. Act of God, can I not argue that earthquake is an act of God if I had act of God?
see so actually there are judgments to that effect that can one party say that earthquake and flood and all these things are act of God, and courts have often actually covered these events into act of God.
Got it.
Yeah.
Got it. Next question. Rahul, if force majeure is nowhere mentioned in my employment contract, then can employers use this clause to terminate my services if I deny to come to office to work?
Uh, Force majeure, if it is not there in your employment contract, obviously the employer cannot resort to it. But if you refuse to go to work, there are policies and there are code of conduct which every employee has to follow. And if you are in breach of any of those policies, then the employer can rely on those policies and still terminate your employment. May not
And your employment agreement terms, basically.
terms of employment. So he may not resort to force majeure because it is not available under the contract, but he can always say that because you refuse to come, you can. It's basically actionable, and disciplinary action can be taken. You can be asked for. You can get a show cause as to why you're not coming, and if you're not working, despite without any reason, then in that case the employer has the ability to terminate.
Gautam, next question. Till how long can force majeure last? Till lockdown over complete or till vaccine released?
So
This is an interesting one. I think, Dheeraj, what I think needs to perhaps be brought out is that it is event based.
right. Right. It is definitely event based, but should we look at the situation? I mean, I'm just being a devil's advocate. Suppose I say a pandemic is a force majeure event, right? So the question falls in that kind of category where, because ultimately the pandemic remains,
Yes.
and it will remain till the time you don't have a vaccine or a So therefore, can you say that till the time pandemic remains, my force majeure event remains? The answer
Also,
to
now with WHO saying it's an endemic, it will never go, it will stay with
yes,
us. I mean,
yes, yes.
what do you do?
So to answer that question is that it is not only the duration for that for which the event subsists, but it is the most important ingredient is that whether the subsistence of that particular event is affecting your performance. So if there is a complete lockdown situation, you are not able to perform. If there is a partial lockdown where lockdown is lifted and private offices are able to run at the capacity of 33%, then you cannot say that it is absolutely impossible for you to perform. You have the ability to perform. So therefore, you need to see not only the event but how that event or the duration of the event is actually affecting or impacting your ability to perform.
Got that. Got that. And Kanish, I want to ask, given the recent times and also a few judgments where courts have taken COVID-19 as a force majeure, if a force majeure clause doesn't cover pandemic specifically, then still could it be covered? I think the key could be lockdown, perhaps. Dheeraj, you'll know better.
Yes, yes, I agree with you. And key is lockdown. I must say that though nowadays people have become very tech savvy, and there are several websites which are giving you notifications on court judgments. But it is also important to understand under what circumstances and whether those judgments are per incuriam. So I'll just explain what is per incuriam. Uh, the courts have, I mean, we generally see those flashes that okay, court has invoked force majeure in such an event. But if you actually see the judgments, courts do say that this is not a force majeure event, but because the situation is such that it demands that certain protection is required to be given. So courts do give protection and call it as a deemed force majeure event, but courts have very clearly said that if an event in a contractual relationship is not identified as a force majeure event, cannot be considered. So we have also seen instances where parties have invoked force majeure and said that we will not be able to pay rent or we will not be able to perform our contract, and court has refused. In fact, there are parties where they said that we are unable to pay our debt. They said that we are unable to perform our part of the contract, and the contract and the court has literally said that sorry, this what is happening for quite some time. So therefore you cannot say that the sudden inability is due to the force majeure event. So court has very carefully looked into facts of each case and then decided. So therefore you may see that the court is saying that force majeure is being implemented, but that is not being implemented very liberally.
Yeah, and Dheeraj, just to say that, just to add to what you were saying, given the government has also used it for all its public procurement contracts, both the pandemic as also the lockdown, perhaps read in conjunction or on a standalone basis, could offer the much needed respite even for private contracts,
Right,
perhaps.
right, right.
Is COVID-19 a force majeure for orange zones?
uh, I'll just give a longer answer to this actually, so that things are pretty clear on in understanding what can be actually a force majeure. Uh, we need to see what government did immediately. That government said that all contracts where supply chain is affected, there you can invoke force majeure. Government categorically said, rather IRDA categorically said, that you cannot invoke force majeure in insurance contracts, right? RBI came up and said, okay, we will give you moratorium, but don't say that it is a force majeure. We understand that generally this event has affected the ability to perform contracts, the ability to make payments also. So as a relaxation, we will give you moratorium, but again not force majeure under the financing document. So we need to be very clear that neither government nor courts have ever said that all these contracts or rather blanket declaration of force majeure except for supply chains. So therefore, force majeure will be always seen in every contract in a different scenario and interpreted in that manner. So therefore, force majeure is not available to us freely. It is only available to us if it is there in the contract. Just because government declares something does not mean that automatically force majeure will apply to our contracts. We need to
Irrespective
keep
of the
in.
zones, you mean to say?
Right, irrespective of the zones. So, if our contract or our services do not fall under supply chain, where force majeure has been invoked by the government, anything except supply chain, force majeure is not there unless it is expressly covered in our contract or it is affecting your ability to perform the contract. So, whether orange zone, red zone, force majeure cannot be applied if it is not available to you or if the government has not declared it as a force majeure event.
And our time's up. I can see Kritika here. So I think we've had a very good and fun session, Kritika. I
I
hope
hope
the
we did not
participants, yeah, I hope the participants found value in it. And, like I always say, we are available around the
Yeah, I'm
campus
sure.
and they can reach out to us for any support or any questions that they may have.
Sure, sure. I'm sure that the participants would have gained much from this session. If you have any closing remarks from them for them, please go ahead.
Uh,
Although you've said most of what needs to be said on contracts and force measure,
no, and I'll
but if there's one
Dheeraj do
closing
the
and
honors. Dheeraj do the honors.
advice that
But
you would want to give.
yeah, given contracts is the most key tool for the future. This is the tool. It has to be used judiciously, it has to be used cautiously, but not overcautiously. And this is the magic key that will bring back the economic spurt. So we have to, build in caution. We have to use it wisely, but
Yeah.
this is perhaps the key tool that we have. Dheeraj, over to you to do us the honors of the closing remarks.
So, I don't know how many people have actually seen their parking receipts at times. There are people, I've seen force majeure events and parking receipts also. And, that trivial, the nature of contract could be that I'm just parking my car. But the importance of contract is a lot. Like, we do everything that is covered under the contract. So, therefore, I think it's time for us to now not be very casual about the contracts, but actually look at them very carefully and see how we can make our life better by having good, well negotiated and discussed contracts.
Not rush into it, but also be do it in a manner that works
Right,
and
workability is
has
important.
its elements of risk, around it.
Right.
Yeah, so that'll be what we'd like to perhaps close the session with, Kritika.
Yeah, we are still getting queries from our participants, so we should be taking them
Uh,
now.
do
Okay.
you want us to
Any
leave
of
them
you,
our
if you
email
have
ID
more
or something?
queries, maybe. Yeah, we can do that. We can do that. But they can send it to our email ID, dipp-startups at nic.in, and you can also give your email IDs if they want to reach out to you directly.
Yeah,
Actually, you can
so I
email
mean,
the
whatever comes to you, please share it with us. Otherwise, do you want me to write our email IDs in the chat? Will the guest be able to see it?
I know
Or
the
should I?
chat is private. Maybe you could just speak it out here.
Yeah. So Dheeraj Maitre, which is DHIRAJ dot MHETRE, Dheeraj.maitre at khaitanlegal.com. And my ID is Shruti, SHRUTI dot Sodhi, SODHI at khaitanlegal.com. And the DIPP ID is right there, and Kritika and Gautam will helpfully pass us
Yeah.
all your questions.
Yes, we would definitely. Thank you, Dheeraj. Thank you, Shruti,
thank
for
you.
a very, very engaging session. And for those of you who couldn't join us for the entire duration of the workshop, you can visit our YouTube, our social media channels where the entire recording of the workshop will be saved for later viewing. Thank you.
Thank
Thank
you
you
very
so
much.
much, Kritika. Thank you. Thank you, Gautam, for the wonderful display of questions as well. That was very helpful.
Thanks, Gautam. Thank you very much for helping with the presentation.